Good day, everyone.
I am Joanna Marie A. Tindugan.
Andrea A. Lapugot.
And Angelina M. Hernandez.
So today, we're going to discuss Lesson 3, which is Intellectual Property Rights on the Development and Use of Digital Materials. Under Module 7, or the Social, Ethical, and Legal Responsibilities in the Use of Technology Tools and Resources. We're going to present what will be the outcomes of this lesson. First, identify examples of intellectual property right in educational setting. Second, define the copyright laws. Third, cited consequences when copyright laws were violated. So before we start, what is intellectual property rights? So according to WTO or the World Trade Organization, intellectual property rights are the rights given to a person over the creation of their mind. So this is made or given to those people to protect their non-physical property like invention, written works, designs, and etc. And according to Duffield and Roberts in Encyclopedia of Applied Plant Science, 2nd edition in 2017, this right is legal and institutional device to protect creation of the mind. They also indicate marks on the products to indicate difference from similar ones sold by competitors. So according to our module, Module 7, Lesson 3, or the Intellectual Property Rights and the Development and Use of the Digital Material, this intellectual property is protected by WIPO or the World Intellectual Property Organization. In our country, we have Intellectual Property Office, and this office was created on the Republic Act number 8293 or the Intellectual Property Code of the Philippines. An act prescribing the Intellectual Property Code and establishing of Intellectual Property Office, providing its power and functions and for other purposes. So what are the importance of knowing intellectual property rights? It is important because it is the protection of ideas, businesses, and individuals. This act is important so that the creators would reap the full benefit of their inventions. In our modern world, this act or this right have significant influence on international and local trade of every nation. So according to St. Francis School of Law of 2021, these are the examples of intellectual property rights: patents, domain names, industrial designs, confidential informations, inventions, moral rights, database rights, works of authorship, service marks, logos, trademarks, design rights, business or trade names, commercial secrets, and computer softwares. So let me define some of these examples. So first is patents. So again, according to WIPO or the World Intellectual Property Organization, a patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. It helps to secure inventor's invention and provide security for the product or design that meets certain specification in step with this originality, utility, and practically. The second one is domain names. So a domain name is an identification string that defines a realm of administrative autonomy, authority, or control within the internet. So this is an example of domain name. So as we can see, the domain name here is the College Board. Next is invention. So invention is a unique or novel device, method, composition, or process, and it's a new solution to a technical problem and can be protected through patents. Last, trademarks. Again, according to WIPO, a trademark is a sign capable of distinguishing the goods, or services of a one enterprise from those of other enterprises. These are protected by intellectual property rights. In this time, where our works are digital, there are chances that our own ideas can be stolen by any third party without our permission. Okay, we already discussed what is intellectual property rights. So let us proceed to one of its type, which is copyright.
Now, let us define copyright. Copyright is a legal right that grants the creator of an original work exclusive rights for its use and distribution. It is a form of intellectual property that protects the original works of authorship in literary and artistic domains, including books, pamphlets, articles, and other writings, periodicals, newspapers, and letters, lectures, sermons, addresses, dissertations prepared for oral delivery, dramatic or dramatico-musical compositions, musical compositions with or without words, works of drawing, painting, architecture, and other works of art, original ornamental designs or models for articles of manufacture, illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science, drawings or plastic works of a scientific or technical character, photographic works, audiovisual works, and cinematographic works, pictorial illustrations and advertisements, computer programs, and other literary, scholarly, scientific, and artistic works. Unlike patents, copyright must be tangible. Once someone created an original work of authorship or OWA, the author automatically owns the copyright. But registering with the U.S. Copyright Office gives the owner a head start in the legal system. The primary objective of copyright is to induce and reward authors through the provision of property rights for them to create new works and make those works available in public. It allows authors, musicians, artists, and etc. to make money out of their creative works. It also prevents others from taking their works for free. It also prevents people from altering their works without permission. Materials covered by the copyright law cannot be used without the owner's permission except in cases such as the fair use clause. Generally, those copyright last for the lifetime of the creator plus 70 years after their death. However, the duration of a copyright can vary due to its publication date and ever-changing copyright laws. As a student, especially in this pandemic, we are always using internet in our way of studying. Most of the topics can be seen in the internet, and we all know that copy and paste are very accessible commands in computer toolbars, but we should be responsible and mindful in using them. We should use them in a good way without violating the copyright laws. Now that we already defined copyright, let us proceed to copyright infringement and plagiarism.
What is copyright infringement? So, it pertains to the violation of someone's intellectual property. It is another term for piracy or the theft of someone's original creation. It occurs when a copyrighted work is reproduced, distributed, performed, or publicly displayed without the permission of the copyright owner. An example of copyright infringement is the use of music in your videos. If you have not obtained the permission to use a song as background music for your movies, presentations, then you could be liable for copyright infringement. So, let's now proceed to the other one, which is the plagiarism. First, let me define what plagiarism is. Plagiarism involves both stealing someone else's work or ideas as your own, with or without the consent of the owner. According to plagiarism.org, it is an act of fraud. Plagiarism.org further elaborates the following as plagiarism. First, giving incorrect information about the source of a quotation. Second, copying so many words or ideas from a source that it makes up the majority of your work, whether you give credit or not.
For images, videos, and music, the following are counted as plagiarism. First, copying media, especially images, from other websites to paste them into your own papers or websites. Second, making a video using footage from others' videos or using copyrighted music as part of the soundtrack. Third, performing another person's copyrighted music, playing a cover. Last, composing a piece of music that borrows heavily from another composition.
Is plagiarism a crime? It is essentially theft and fraud committed simultaneously. It is considered theft because the writer takes ideas from a source without giving proper credit to the author. So let's now move on to the difference between copyright infringement and plagiarism. So when we say copyright infringement, it is the violation of the right of the holder, while plagiarism is the violation of the right of the author. In addition, copyright infringement is a legal violation, while plagiarism is an ethical violation.
The legal penalties for copyright infringement are: infringer pays the actual dollar amount of damages and profits. Infringer pays for all attorney's fees and court costs. The infringer can go to jail.